Case 1. Janine Ann Jones. A pharmacy vial with a puncture mark, an infant's tissue sample that came back positive for a paralytic drug, and a pattern so consistent, so statistically concentrated on one nurse's shifts, that a Centers for Disease Control and Prevention expert would later testify that children in that pediatric unit were 25 times more likely to go into cardiac arrest during her working hours. That is where this case begins. Not with suspicion, but with numbers, with science, with a paper trail that investigators would spend years assembling across 2 Texas cities and more than 3 decades of legal proceedings. Case 1 is Janine Ann Jones. Janine Ann Jones was a licensed vocational nurse working in pediatric intensive care in San Antonio, Texas. Her credentials allowed her direct access to the most vulnerable patient population in any hospital setting: infants and toddlers too young to communicate, too small to resist, entirely dependent on the adults in that room. She worked the pediatric intensive care unit at Bexar County Hospital, now known as University Hospital, during the early 1980s. She later moved to a private pediatric clinic in Kerrville, Texas, operated by Dr. Kathleen Holland. The pattern that investigators would eventually document began in San Antonio. Medical staff and administrators at Bexar County Hospital noticed an unusual clustering of medical emergencies, cardiac events among pediatric patients, concentrated during the 3 to 11 p.m. shift. Internal reviews were conducted. A CDC expert was later brought in to analyze the data. That expert's finding was precise. During a 15-month period identified as the epidemic window, children on that evening shift were 25 times more likely to experience cardiac arrest and 10 times more likely to die than at any other time in that unit. The clustering aligned with one variable: the nurse on duty. Jones left Bexar County Hospital and began working at Dr. Holland's pediatric clinic in Kerrville in the spring of 1982. The pattern continued. Children brought to that clinic for routine appointments began experiencing medical emergencies on site. It was in Kerrville that the case reached a turning point. On September 17, 1982, Chelsea McClellan, a 15-month-old child, died following an appointment at Dr. Holland's clinic. Chelsea's death triggered a focused investigation. Dr. Holland, reviewing her medical supplies, found a puncture mark in a vial of succinylcholine, a powerful paralytic drug used in surgical and emergency settings that has no routine application in an outpatient pediatric clinic. That puncture mark, that single piece of physical evidence, was the beginning of a forensic chain. Investigators ordered the exhumation of Chelsea McClellan. Tissue samples were analyzed at toxicology laboratories. The results confirmed the presence of succinylcholine in Chelsea's remains. The forensic detection of succinylcholine post-mortem was itself notable. The drug breaks down rapidly in the body, and confirming its presence required precise laboratory methodology applied to biological samples preserved through the exhumation process. Law enforcement also reviewed the case of Rolando Santos, a 4-week-old infant who had experienced a near-fatal medical emergency at the Bexar County Hospital during Jones's shifts and survived. Santos became the basis for a separate criminal charge. Janine Jones was arrested and charged in 1983. Her trial proceeded in Kerrville in February of 1984. The prosecution presented the forensic toxicology findings, the punctured vial, the shift clustering data, and testimony from Chelsea McClellan's mother, Petty McClellan, who described the sequence of events at the clinic on the day of Chelsea's death. Kerrville prosecutor Ron Sutton laid out a documented pattern: emergencies that arose specifically when Jones was present, with patients who had been stable before and after her involvement. The jury returned a conviction. Jones was sentenced to 99 years in prison for the murder of Chelsea McClellan. She received a concurrent sentence of 60 years for the injury to Rolando Santos. However, the legal proceedings did not end there. Investigators and prosecutors in Bexar County had long believed the San Antonio deaths warranted separate criminal charges. For years, that process was complicated by destroyed hospital records. Bexar County Hospital had reportedly disposed of documentation during the investigation period, a fact that drew significant criticism and scrutiny of institutional practices. There was also a structural legal problem. A 1977 Texas prison overcrowding law, known as the Mandatory Supervision Statute, was written in a way that would have automatically triggered Jones's release in approximately 2018, regardless of the severity of her crimes, due to time served and good conduct credits. The prospect of her release generated significant concern among investigators and families. In May of 2017, Bexar County District Attorney Nicholas LaHood announced new indictments against Jones for multiple additional patient deaths that had occurred during her time at Bexar County Hospital. Investigators had worked for years to identify cases where evidence could still support prosecution, despite the passage of more than 3 decades. Among those charges was the death of Joshua Sawyer, an 11-month-old child who had died in 1981. In January of 2020, Jean Jones entered a guilty plea to the murder of Joshua Sawyer. She received a life sentence for that conviction. The guilty plea and resulting life sentence legally prevented her early release under the 1977 Mandatory Supervision Statute. She remains incarcerated. The total scope of Jones's actions has been the subject of ongoing investigative and journalistic review. Bexar County officials estimated she may have been responsible for the deaths of as many as 60 children. That figure represents investigative suspicion and prosecutorial analysis, not adjudicated convictions. Jones was convicted of 2 deaths, Chelsea McClellan and Joshua Sawyer, and of the non-fatal injuring of Rolando Santos. The institutional aftermath of this case was substantial. Texas Monthly's detailed coverage of the case documented failures at multiple levels: supervisory, administrative, and licensing. Jones's nursing license was not formally revoked until 2011, nearly 30 years after the events at Bexar County Hospital. The case became a landmark example, studied in healthcare administration and nursing regulation, for what happens when internal warning signs are identified, but institutional action is delayed or incomplete. It contributed to broader discussions about interfacility reference practices. Specifically, what information is disclosed when a nurse transfers between employers. Criminologists and forensic analysts who have studied this case have noted the motive structure argued by prosecutors. Jones allegedly sought to create medical emergencies and then position herself as the person managing the crisis, a behavioral pattern that generated attention, professional recognition, and a sense of importance within the unit. This framework was presented as contextual background by prosecutors and has been cited in subsequent academic literature on healthcare workers who harm patients. Jenu Ann Jones remains one of the most extensively documented cases of patient harm by a licensed healthcare worker in the history of Texas criminal proceedings. Her case established procedural precedents in the investigation and prosecution of clustered patient deaths in medical settings, contributed to changes in how Texas tracks nursing license status, and demonstrated that forensic toxicology, when precisely applied, can detect substances in biological samples even years after the events in question. The pattern was in the data long before the indictment. That is what investigators found. That is what the jury decided. And that is what the record reflects. Case 2. Vicki Dawn Jackson. The investigation started with a count. A pharmacy technician at a small-town Texas hospital conducted a routine inventory check and found that 14 vials of a paralytic drug were missing. That count, 14 vials against 0 legitimate medical orders for that drug, set off what would become a joint investigation involving local police, the Texas Rangers, and the Federal Bureau of Investigation. The result was one of the most significant healthcare criminal prosecutions in the history of North Texas. Case 2 is Vicki Dawn Jackson. Vicki Dawn Jackson was a licensed vocational nurse who had held her license since 1989. She worked night shifts at Nocona General Hospital in Nocona, Texas, a small community hospital in Montague County, in the northern part of the state. Nocona General Hospital served a rural patient population, many of them elderly residents admitted for conditions that, under ordinary circumstances, would not be expected to result in rapid deterioration or death. The period under investigative focus runs from December of 2000 through February of 2001. During those approximately 3 months, a cluster of patient deaths occurred at Nocona General that exceeded any reasonable statistical expectation for a facility of that size and patient profile. Many of the patients who died had been admitted with relatively minor ailments. Their ages ranged from 62 to 100 years old. The break in the case came from pharmacy records rather than medical examinations. A pharmacy technician conducting an inventory check identified a discrepancy: vials of mivacurium chloride, a neuromuscular blocking agent used in surgical and intensive care settings to induce temporary paralysis, were missing from the hospital's pharmaceutical stock. The drug, marketed under the name Mivacron, had no documented clinical orders at Nocona General Hospital during the period in question. There was no legitimate reason for those vials to have been accessed, let alone removed. Nocona Police Chief Kent Holcomb described the moment the discrepancy was flagged. The missing vials, he noted in subsequent interviews, were a significant alert. Separately, on February 8, 2001, the hospital's pharmacist filed a formal report with the Texas State Board of Pharmacy documenting that at least 10 vials of Mivacron injection had been lost or stolen from the facility's inventory. That report became a key document in the investigation. Investigators then cross-referenced the dates of patient deaths against Jackson's shift schedule. The correlation was documented and consistent. Deaths occurred during the windows when Jackson was on duty. The pattern was not explained by patient condition, age alone, or any other documented clinical variable. Jackson was removed from her nursing duties on February 21, 2001. The criminal investigation continued as law enforcement worked to build forensic evidence sufficient to support prosecution. That process required exhumations. Beginning in 2001, investigators initiated the exhumation of deceased patients from the period under review. The FBI laboratory conducted toxicology testing on the biological samples recovered. Those tests detected mivacurium chloride in the tissues of multiple patients. Mivacurium chloride, like succinylcholine, is a drug that metabolizes rapidly in the body, and its forensic detection required precise analytical methods applied to preserved biological material. Additionally, law enforcement conducted a search that yielded a critical piece of physical evidence. A syringe containing traces of mivacurium chloride was recovered from Jackson's residential trash. That syringe connected Jackson directly to the drug identified in the exhumation results. Jackson was arrested on July 16, 2002. By that point, she was working at a grocery store, having left healthcare employment. She was charged with capital murder. As the investigation continued and additional exhumation results were processed, the charge count grew. Ultimately, Jackson faced 10 counts of capital murder, one for each patient death that investigators and prosecutors determined could be supported by the available forensic and circumstantial evidence. The investigation was a coordinated effort among the Nocona Police Department, the Texas Rangers, and the FBI. The Texas Rangers' involvement brought specialized investigative resources to what began as a local case. The FBI's laboratory capabilities were essential to the toxicological analysis that formed the evidentiary core of the prosecution. During the pretrial period, FBI Special Agent David Burns provided testimony regarding statements Jackson had made. Those statements included expressions of anger and frustration directed at patients she described as being demanding. That testimony was presented as relevant to motive in the context of the capital murder charges. Investigators also learned that Jackson's adult daughter was prepared to testify against her mother. Defense attorneys later cited this anticipated testimony as a significant factor in the ultimate resolution of the case. The prospect of family testimony against a defendant in a capital case is an unusual and legally significant development that shaped the negotiations. On the question of capital murder charges in Texas, the state may seek the death penalty when specific statutory aggravating factors are present. In Jackson's case, the Montague County District Attorney's Office made the determination not to seek the death penalty. The case instead proceeded toward a plea resolution. Vicki Dawn Jackson entered a plea of no contest to the capital murder charges. Under Texas law, a no contest plea to capital murder carries an automatic sentence of life in prison when the death penalty is not being sought by the state. Jackson entered that plea and received the automatic life sentence. She waived her right to appeal at the time of the plea. Jackson's earliest possible parole eligibility has been reported as approximately 2042. The legal proceedings did not conclude entirely with the guilty plea. In 2015, Jackson returned to court for an evidentiary hearing in which her legal team sought a new trial. A central issue at that hearing was the physical evidence, specifically the syringe recovered from her trash. That syringe, which had contained traces of mivacurium chloride and had been a critical piece of physical evidence, had since been destroyed as part of routine evidence disposal procedures. The evidentiary hearing addressed whether the destruction of that evidence, combined with other factors, warranted relief from the conviction. The court did not grant a new trial. The Nocona General Hospital case illustrates several recurring themes in the investigation of patient harm by healthcare workers. The first is the role of pharmacy inventory management. It was not a physician, a patient complaint, or a family member's concern that initiated the formal investigation. It was a pharmacist and a technician performing a routine count. That count revealed the missing vials. In small community hospitals, pharmaceutical inventory systems are the first and sometimes the only line of defense against controlled substance diversion and misuse. The second theme is the importance of forensic toxicology combined with shift schedule analysis. Investigators in this case used two distinct evidentiary categories: the statistical pattern of deaths aligned to one nurse's schedule and the biological confirmation of a specific drug in exhumed remains. And those two categories reinforced each other in court. The third theme is the institutional challenge of small facilities. Nocona General Hospital, as a rural community hospital, had limited staffing options, limited supervisory infrastructure, and limited resources for the kind of active monitoring that might have flagged the pattern earlier. The deaths occurred over approximately 3 months before the pharmacy count triggered the investigation. Vicki Dawn Jackson remains incarcerated. The 10 patients whose deaths were charged as capital murder ranged in age across nearly 4 decades of human life, from their early 60s to 100 years old, and all had been admitted with conditions that, under ordinary medical circumstances, would not have been expected to result in death during a short hospital stay. The investigation, the forensic work, and the prosecution of this case stand as a reference point for how rural healthcare facilities approach pharmaceutical accountability and staffing oversight to this day. Case 3. Kimberly Clark Sands. 2 patients sat in their dialysis chairs on April 28, 2008, when they independently observed the same thing: a nurse drawing a liquid from a bleach-containing solution into syringes and injecting it into patients' dialysis lines. Both patients would later testify to what they saw. The forensic confirmation of their testimony required a technique so novel at the time that the chemist who applied it would become a key witness in a capital murder trial. Case 3 is Kimberly Clark Sands. Kimberly Clark Sands was a licensed vocational nurse employed at a DaVita dialysis clinic in Lufkin, Texas, in Angelina County in East Texas. She had been employed at the facility for less than 1 year at the time of the events under prosecution. Dialysis patients are a medically vulnerable population. They receive treatment multiple times per week for chronic kidney failure. They are connected to machines that filter their blood, and the fluid pathways in that process create direct access to a patient's bloodstream. Any substance introduced into a dialysis line enters the body through that pathway. The clinical events began in April of 2008. On April 1, 2008, 2 patients died at the DaVita clinic in Lufkin. The deaths were medically unexpected, given the patient's presenting conditions on that treatment day. More patient deaths followed in subsequent days. The cluster of cardiac events and deaths within a short window at a single dialysis facility was sufficiently unusual that it triggered review by facility management and eventually by public health investigators. A Centers for Disease Control and Prevention epidemiologist was brought in to analyze the pattern. That analysis produced a finding that would become central to the prosecution. The epidemiologist's review determined that Sands was present at every patient death that occurred at the clinic during the relevant period in April 2008. No other single staff member's presence correlated with the pattern in the same way. The eyewitness testimony came from 2 dialysis patients who were receiving treatment on April 28, 2008. Linda Hall and Lurleen Hamilton, both patients at the facility, independently observed Sands engaging with the bleach supply used for equipment cleaning and then introducing material from syringes into patient dialysis lines. Both patients provided formal statements to investigators describing what they had witnessed. Their testimony would become a cornerstone of the prosecution's case at trial. The forensic investigation involved the collection of syringes and blood tubing from the clinic. Testing confirmed the presence of bleach components in that physical evidence. But the most significant forensic development came from the biological samples taken from the victims. The prosecution engaged forensic chemist Mark Sochaski to conduct a novel analytical process. Sochaski applied a technique to detect chlorotyrosine in the victim's blood. Chlorotyrosine is a biomarker, a biological compound that forms in the bloodstream as a result of exposure to bleach or chlorine-based substances. Its presence in biological samples is specific to that type of exposure. The application of this technique to the victim's blood was presented at trial as a forensic first in this type of case. The results were positive. The victim's blood showed the chlorotyrosine signature consistent with bleach exposure. Investigators also obtained records from Cyans's personal computer. A forensic review of those records revealed that she had conducted internet searches related to bleach, including searches about whether bleach could be detected in a person's body. Those search records were recovered through digital forensic analysis and were presented to the jury as evidence of pre-event awareness and intent. Cyans was fired from the DaVita Clinic, and her nursing license was suspended following the initial investigation. She was formally charged in 2009. The charges reflected the scope of what prosecutors documented: 5 counts of capital murder and multiple counts of aggravated assault with a deadly weapon. The 5 patients identified in the capital murder counts were Clara Strange, Thelma Metcalf, Garland Kelly, Cora Bryant, and Opal Few. 5 additional patients were identified in the aggravated assault charges as individuals who survived following unexplained medical events at the clinic during the same period. The prosecution presented the 5 deaths and 5 injuries as parts of a connected pattern of conduct. Cyans's trial began in March of 2012 in Angelina County. Prosecutors sought the death penalty, which under Texas law requires an affirmative finding by the jury that the defendant poses a continuing threat to society. The trial included testimony from the 2 eyewitness patients, from forensic chemist Sochaski on the chlorotyrosine findings, from the CDC epidemiologist on the statistical pattern of Cyans's presence at each death, and from investigators regarding the digital evidence recovered from her computer. The defense, led by attorney Ryan Deaton, challenged the forensic methodology and argued that DaVita, the corporate operator of the clinic, bore institutional responsibility for the patient deaths and was using Cyans as a scapegoat to deflect from its own procedural failures. The defense questioned the reliability of the chlorotyrosine analysis and the adequacy of the facility's own contamination prevention protocols. Angelina County District Attorney Clyde Harrington, in statements during and after the trial, expressed his belief that the total number of patients affected by Cyans's conduct exceeded the 10 individuals named in the indictments. On March 30, 2012, the jury returned its verdict: guilty on the capital murder charges and guilty on the aggravated assault charges. On April 2, 2012, the jury declined to impose the death penalty and instead recommended a life sentence without the possibility of parole. The court imposed that sentence, along with 3 consecutive 20-year sentences for the aggravated assault convictions, an aggregate 60 years consecutive to the life without parole term. Cyans was transferred to the Texas Department of Criminal Justice to serve her sentences. She has maintained her innocence in subsequent interviews and communications. The appeal of her conviction followed an unusual procedural path. The Texas Court of Criminal Appeals, the state's highest criminal court, returned the case to the Intermediate Appellate Court over a question related to jury instructions. On remand, the Intermediate Appellate Court affirmed the conviction and sentence. The case's appellate history highlights the complexity of capital murder prosecutions and the level of judicial scrutiny applied to the jury instruction process in cases where the death penalty is sought. The Kimberly Sands case contributed significantly to the forensic science literature on bleach exposure detection in biological samples. The chlorotyrosine methodology, applied by Sochaski, had not previously been used in a criminal prosecution of this type, and the Lufkin trial placed that technique into the documented record of forensic chemistry as applied in court. Subsequent discussions of the case in medical and legal literature have focused on both the evidentiary value of biomarkers in poisoning cases and the procedural questions raised about medical facility oversight. The DaVita Clinic in Lufkin closed following the investigation and prosecution. The case prompted review of clinical protocol in dialysis settings, specifically the handling and storage of cleaning agents in proximity to treatment areas and the separation of those materials from patient care pathways. Case 4. William George Davis. Brain imaging told the story before a single witness took the stand. When radiologists and medical specialists reviewed scans of patients who had died in the cardiovascular intensive care unit of a Tyler, Texas hospital in 2017 and 2018, they found something that an experienced pulmonologist testified he had never seen in his medical career: air in the cerebral arterial system. That finding, air where blood should be, was the forensic foundation of a capital murder prosecution that ended with a sentence of death. Case 4 is William George Davis. William George Davis was a registered nurse working in the cardiovascular intensive care unit at Christus Trinity Mother, Francis Louis, and Peaches Owen Hart Hospital in Tyler, Texas, in Smith County. Cardiovascular intensive care patients are among the most medically fragile in any hospital. They are recovering from heart surgery, they are connected to monitoring equipment, and they require continuous, attentive nursing care during their recovery period. The unit where Davis worked served patients who had recently undergone cardiac procedures and were in the critical window following intervention. The pattern of unusual patient deaths began in 2017 and continued into 2018. Hospital administration and medical staff identified a cluster of unexpected deaths in the cardiovascular ICU. Patients who had undergone procedures and were in recovery, whose clinical decline was not accounted for by their documented surgical outcomes or pre-existing conditions. The pattern prompted an internal review, and that review led to the involvement of law enforcement. Davis was arrested in April of 2018. The Smith County District Attorney's Office, under prosecutors Chris Gatewood and Jacob Putman, filed charges of murder and aggravated assault with a deadly weapon in June of 2018. As the investigation developed further, the charges were elevated to capital murder, the charge applicable under Texas law when multiple victims are involved in a single course of criminal conduct. The forensic cornerstone of the prosecution was medical imaging. Pulmonologist Dr. William Yarbrough testified at trial that brain scans of the deceased patients revealed air in their cerebral arterial systems. Dr. Yarbrough testified that in his professional experience, he had not previously encountered this finding. Air in the cerebral arterial system, specifically the introduction of air into a patient's bloodstream through an intravenous line, can cause a cascade of medical events that lead to death. In a cardiovascular ICU, where patients are connected to IV lines and monitoring systems as part of standard postoperative care, the access required to introduce air into an IV line is available to any nurse working with that patient. The prosecution also relied on staffing and scheduling records. Investigators reviewed payroll and shift assignment documentation for the cardiovascular ICU during the relevant period and established that Davis was the nurse assigned to the patients who died or experienced unexplained medical emergencies in each of the relevant cases. Security footage was reviewed and showed Davis entering patient rooms in the time windows immediately preceding the emergency events. Additionally, a digital investigation was conducted by a Secret Service agent with expertise in electronic evidence. That review uncovered internet search activity from Davis's accounts, searches for lists of serial killers, and searches that included the name of the hospital where he worked. Those digital records were recovered through standard forensic processes applied to electronic devices and account activity, and the Secret Service agent testified about their content and their recovery methodology. Jailhouse recordings also became part of the prosecution's evidence. Following his arrest, Davis participated in recorded telephone conversations from the jail. Prosecutors played portions of those recordings for the jury. In those calls, Davis was recorded discussing the ICU setting in terms related to work hours and financial compensation. Specifically, the economic value of extended ICU patient stays to nursing staff who work those units. He also described the patient deaths as accidental occurrences. Prosecutors argued those recordings, taken together with the other evidence, reflected both knowledge and intent. Prosecutors in this case charged Davis with the deaths of 4 patients: John Lafferty, Ronald Clark, Christopher Greenaway, and Joseph Kalina. All 4 were adult men who had been admitted to the cardiovascular ICU as post-surgical recovery patients. Their deaths, viewed in isolation, might have been attributed to the inherent risks of cardiac surgery in patients with pre-existing heart conditions. Viewed together, with the staffing overlap, the imaging findings, and the subsequent digital evidence, prosecutors argued they reflected a pattern. The prosecution presented evidence of additional deaths and injuries during the sentencing phase of the trial, with claims that the total number of patients affected by Davis's conduct was at least 11, of whom approximately 7 died. Those additional cases were presented during the capital sentencing phase, where the state must demonstrate future dangerousness, rather than as separate murder counts. Prosecutors noted in post-verdict statements that the decision to charge only 4 deaths was based on the evidentiary standard required for capital murder prosecution, a threshold they could meet conclusively in those 4 cases. The trial took place in Smith County in October of 2021. On October 19, 2021, the jury returned a verdict of guilty on the capital murder charge. 8 days later, on October 27, 2021, the jury imposed the death penalty. Davis was transferred to the Pulmonologist unit of the Texas Department of Criminal Justice, which houses Texas's death row, to await execution. Defense attorney Philip Hayes argued throughout the trial that Davis was a scapegoat for institutional failures at the hospital, that the deaths had other explanations, and that the hospital's administration had identified Davis as a target to deflect accountability for systemic problems in the unit. The jury rejected that argument. The automatic appellate review of the death sentence proceeded to the Texas Court of Criminal Appeals, which affirmed both the conviction and the sentence. The court reviewed and rejected defense arguments regarding the future dangerousness finding required for capital punishment under Texas law, and addressed the question of whether the evidence sufficiently established intentional conduct by Davis toward each of the 4 identified victims. Prosecutors Gatewood and Putman stated after the verdict that one of the most significant evidentiary facts in the case was the statistical record of the hospital itself. In the period after Davis was removed from the unit and subsequently arrested, the cardiovascular ICU returned to normal clinical outcome patterns. The cluster of unexplained deaths and emergencies ceased when his employment ended. The William Davis case has been studied in discussions of healthcare facility oversight, staffing pattern analysis, and the investigative tools available to law enforcement when investigating potential patient harm in clinical settings. The combination of medical imaging forensics, digital evidence recovery, shift schedule cross-referencing, and recorded communications represents a multi-channel evidentiary approach that set a reference standard for subsequent investigations. Davis remains on death row in Texas, the only currently death-sentenced individual among the cases documented in this series. His case is subject to ongoing appellate review under the mandatory review provisions applicable to capital cases in Texas. Case 5. Ernesto Pedraza. The complaints came from patients. Male patients who had been admitted to Houston area hospitals for medical treatment and found themselves in a state of reduced consciousness, incapacitated by illness or sedation, unable to communicate fully, dependent entirely on the nursing staff around them. Their reports were made formally, and those reports triggered the investigations that would ultimately result in a criminal prosecution and a 15-year prison sentence. Case 5 is Ernesto Pedraza. Ernesto Pedraza worked as a nurse's aide at 2 Houston area medical facilities, Ben Taub Hospital and Kingwood Medical Center. Nurses' aides, sometimes referred to as nursing assistants or patient care technicians, are frontline healthcare workers who provide direct physical care to patients. Their duties include personal hygiene assistance, mobility support, vital sign monitoring, and patient comfort measures. They work in close physical proximity to patients, frequently in one-on-one settings, and in many cases are the healthcare workers who spend the most continuous time in direct contact with individual patients. Ben Taub Hospital is a major public hospital in the Texas Medical Center in Houston, operated by Harris Health System and serving as one of the primary trauma and acute care facilities in the region. Kingwood Medical Center is a community hospital located in the Kingwood area of northeastern Harris County. The 2 facilities represent different patient populations and geographic areas, but both fell within the scope of the investigation into Pedraza's conduct. The offenses documented in this case occurred during 2015 and 2016. The victims were male patients who were incapacitated at the time, individuals whose medical condition, treatment, or sedation had reduced their ability to resist, communicate clearly, or fully recall events. The Harris County District Attorney's Office, in processing the case, cited multiple allegations involving this patient population. The investigation was initiated by formal patient complaints submitted to the hospitals. Both facilities took the complaints seriously and acted upon them. Ben Taub Hospital and Kingwood Medical Center separately reviewed the allegations, conducted internal investigations, and terminated Pedraza's employment. The complaints and the resulting institutional investigations formed the basis for law enforcement's engagement with the case. The case proceeded to the Harris County Criminal Court System. A jury trial was held, at which the prosecution presented the victim accounts and supporting investigative evidence. The jury returned a verdict of guilty on the charge of sexual assault. In August of 2019, Ernesto Pedraza was sentenced to 15 years in the Texas Department of Criminal Justice. The Pedraza case highlights a specific dimension of patient vulnerability in healthcare settings that differs from the clinical and pharmaceutical crimes documented in other cases in this series. Whereas cases involving medication, pharmaceutical agents, or diagnostic findings leave physical evidence that forensic laboratories can test and analyze, cases involving sexual assault of incapacitated patients depend substantially on patient testimony, witness accounts, and the credibility assessments made by investigators and juries. The capacity of incapacitated patients to accurately report and describe their experiences, and the legal framework for evaluating that testimony, are central issues in the prosecution of these cases. The case also illustrates the importance of internal hospital complaint systems and the willingness of institutions to act on reports from patients whose accounts may be incomplete due to their medical condition at the time. Both Ben Taub Hospital and Kingwood Medical Center responded to patient complaints by conducting reviews and taking employment action, which contributed to the documentation that supported the criminal prosecution. Healthcare industry discussions following this case and similar cases have focused on several protective mechanisms: visitor access controls in patient rooms, surveillance infrastructure in care settings, background screening protocols for hiring, and staff supervision ratios in units where patients may be sedated or otherwise incapacitated. The accessibility of patients in reduced states of consciousness to individual staff members working independently has been identified as a structural vulnerability that institutional policies must address. The Pedraza conviction stands as a documented case in Harris County court records. He received a 15-year prison sentence for the offenses committed against incapacitated patients in his care. The case reinforces the obligation of healthcare institutions to maintain reporting systems that are accessible and functional for all patients, including those who are temporarily or permanently unable to communicate at full capacity. Case 6. The Novus Health Services Nurses. The organization was built on a fundamental deception: hospice care operated for profit by a person with no medical license, who directed licensed nurses to admit patients regardless of clinical eligibility and, according to court records and federal prosecution, instructed staff to administer drugs to hasten patient deaths. The scheme generated more than $40 million in fraudulent Medicare and Medicaid billing. 4 nurses were convicted. 13 defendants in total received a combined roughly 84 years in prison. Case 6 is the Novus Health Services Nurses. Novus Health Services was a hospice company based in Frisco, Texas, in Collin County in the Dallas-Fort Worth metropolitan area. The company was founded and operated by Bradley Harris, who was an accountant with no medical training and no medical license. Harris controlled the clinical operations of the hospice, the admissions, the discharges, the medications, and the level of care, not through medical authority he legitimately held, but through institutional control he exercised as the company's chief executive. Hospice care, under federal Medicare and Medicaid regulations, is a specific benefit category available to patients who are certified by a physician as having a terminal illness with a life expectancy of 6 months or less if the disease follows its normal course. Hospice patients are enrolled in a care model that prioritizes comfort and palliative treatment over curative intervention. Billing for hospice services is only lawful when the patient meets the eligibility criteria and when the care provided corresponds to the documented patient needs. Novus Health Services enrolled patients in hospice care regardless of whether they met the clinical criteria for that benefit. The company engaged physicians, Dr. Mark Gibbs and Dr. Layla Hergy were among those prosecuted, to certify patients as eligible for hospice through a process that, according to court records and testimony, involved pre-signed prescription pads and certifications for medical examinations that never actually occurred. The physicians signed off on eligibility determinations without conducting the required clinical evaluations. The nurses employed by Novus, including registered nurses Tammy Little, Jessica Love, and Patricia Armstrong, and licensed vocational nurse Taryn Stewart, were the operational implementers of the scheme. They carried out patient admissions, determined medication regimens, and administered drugs. In an organization without functioning physician oversight, the nurses' clinical decisions were directed by Harris, the non-physician CEO, rather than by licensed medical authority. Federal court records and trial testimony described a specific and serious dimension of the scheme, In addition to fraudulent billing for ineligible patients, there were allegations that nurses were directed to administer medications, specifically opioid analgesics including morphine, in dosages designed to accelerate patient deaths rather than to manage pain and provide comfort care. The death of a hospice patient generates a final billing event and closes the enrollment, making room for a new billable admission. Accelerating deaths increase the facility's patient throughput and revenue. The evidence of these instructions came from multiple sources. Bradley Harris, who entered a guilty plea and cooperated with federal prosecutors, testified about the operational directives he had given. Melanie Murphy, the company's director of operations, testified in terms that the prosecution used to illustrate how clinical authority had been entirely displaced from licensed physicians. She told the court, in substance, that she functioned as the physician in terms of what actually happened at the organization. Court records reflected that Harris sent text communications to staff that included explicit language about hastening specific patients' deaths. The FBI's Dallas Field Office, the Department of Health and Human Services Office of Inspector General, and the Texas Attorney General's Medicaid Fraud Control Unit collaborated on the investigation. The financial investigation was substantial. Investigators documented a fraudulent billing scheme totaling more than $40 million. Harris was ordered to pay restitution of approximately $27,594,875.52. Dr. Mark Gibbs was ordered to pay approximately $27,978,903. Dr. Layla Hergy was ordered to pay approximately $16,253,281. The FBI conducted a raid on Novus Health Services offices in September of 2015. The prosecutions that followed extended across several years, with various defendants entering pleas or proceeding to trial at different points. Tammy Little, a registered nurse, was convicted at trial on charges of conspiracy to commit healthcare fraud and 3 substantive counts of healthcare fraud. She was sentenced to 33 months in federal prison. Jessica Love, a registered nurse, pleaded guilty and received a sentence of 102 months, 8.5 years, in federal prison. Patricia Armstrong, a registered nurse, pleaded guilty and was sentenced to 84 months, 7 years. Taryn Stewart, a licensed vocational nurse, pleaded guilty and received a sentence of 96 months, 8 years. The physicians received substantially longer sentences. Dr. Mark Gibbs received 13 years, and Dr. Layla Hergy received 10 years. Bradley Harris, the CEO and the individual at the center of the scheme, received a sentence of 159 months, approximately 13 years and 3 months. In total, 13 defendants in the Novus Health Services prosecution received a combined roughly 84 years in federal prison. U.S. Attorney Prerak Shah and Acting U.S. Attorney Chad Meacham, in statements following the sentencings, addressed the nature of the offense, allowing a non-physician with no medical qualifications to direct clinical decisions, including end-of-life medication decisions, for vulnerable hospice patients. The case represented not only healthcare fraud, but the subversion of the licensed medical structure that is designed to protect patients from exactly this type of exploitation. The Novus Health Services case is significant for what it illustrates about the systemic dimensions of healthcare fraud. The nurses convicted in this case did not operate independently. They functioned within a structure created and controlled by an organization whose leadership had constructed a system in which clinical boundaries were systematically violated for financial gain. The individual convictions of the nurses coexist with the broader institutional accountability established through the prosecution of the physicians and the CEO. Medicare and Medicaid oversight mechanisms subsequently cited this case as an example of the failure modes in hospice benefit administration. Specifically, the potential for fraudulent billing when physician certification requirements are treated as paperwork formalities rather than genuine clinical gatekeeping. Case 7. Alexis Joanne McNeely. The pharmacy audit flagged the discrepancy. A routine review of the automated dispensing cabinet records at Houston Methodist Hospital in the spring of 2023 identified something that could not be explained by any legitimate patient order or authorized medication withdrawal: tampered vials. Vials that had been accessed by one nurse's credentials, emptied of controlled substances, refilled with saline solution, and returned to the cabinet for use by other staff on unsuspecting patients. Surveillance footage confirmed what the records indicated. Case 7 is Alexis Joanne McNeely. Alexis Joanne McNeely was a registered nurse employed at Houston Methodist Hospital, one of the largest and most prominent hospital systems in the Texas Medical Center in Houston. Before her employment at Houston Methodist, she had worked at Baylor University Medical Center in Dallas. Her nursing credentials gave her authorized access to the hospital's controlled substance dispensing systems. Specifically, the Pyxis automated dispensing cabinets that hospitals use to manage medication access, track withdrawals, and maintain a chain of custody for controlled substances. The Pyxis system is designed with accountability in mind. Each access requires a nurse's individual credentials. Each withdrawal is logged with a timestamp, a patient identifier, a medication name, and the quantity removed. The system creates a continuous electronic record of every controlled substance transaction, and pharmacy staff conduct periodic audits of that record to identify discrepancies between what was withdrawn and what was documented as administered. It was during one of those routine audit processes, in May of 2023, that a pharmacy director at Houston Methodist identified irregularities associated with McNeely's access records. The pattern was not consistent with authorized medication withdrawals for patient care. The pharmacy alerted hospital administration, which in turn notified the Drug Enforcement Administration and the Houston Police Department. The investigation that followed used both the electronic Pyxis records and the hospital's surveillance camera system. Footage from the cameras covering the medication dispensing area showed McNeely at the cabinet during the relevant time periods. The footage documented her withdrawing vials of fentanyl and hydromorphone, 2 Schedule II controlled opioids, and, critically, showed her refilling those vials with saline solution before returning them to the cabinet. On at least one occasion documented in the surveillance footage, she was observed injecting the withdrawn controlled substance herself. The substitution of saline for controlled substances is a crime that operates on 2 levels simultaneously. The first is the theft of the controlled substance itself, a federal crime under the Controlled Substances Act. The second, and the dimension that creates direct patient harm, is the return of the tampered vials to the medication supply. When those saline-filled vials were subsequently pulled from the cabinet by other nurses for authorized patient use, patients received saline injections rather than the pain medication or other therapy they had been prescribed. The clinical consequences depend on the patient's condition and the medication involved, but in any case, the patient does not receive the prescribed treatment. The investigation also uncovered McNeely's employment history. At her previous employer, Baylor University Medical Center in Dallas, she had tested positive for controlled substances in a workplace drug test, an event that should have been, and was, reported through the healthcare employment verification infrastructure. The details of how that prior event affected her subsequent employment at Houston Methodist were examined as part of the broader case review. McNeely was charged with multiple felony counts of diversion of a controlled substance in December of 2023 and was arrested on December 28, 2023. She entered a plea of guilty to 2 counts of diversion of a controlled substance. The plea agreement resolved the charges without a trial. In August of 2024, McNeely was sentenced to 120 days in the Harris County Jail and 4 years of probation. As part of the resolution of her case, she permanently surrendered her Texas nursing license. That surrender was accepted by the Texas Board of Nursing and constitutes a lifetime bar from nursing practice in Texas. Harris County District Attorney Kim Ogg and prosecutors Michael Eber and Kelsey Davis issued statements following the sentencing that emphasized public safety, specifically the protection of patients from healthcare workers who misuse their access to controlled substances in ways that compromise patient care. The McNeely case reflects a pattern documented across healthcare settings nationally. Registered nurses with opioid use disorders who divert controlled substances through the access their professional credentials provide. The Pyxis system and similar automated dispensing technology were developed in part to create accountability that reduces this type of diversion. The McNeely case demonstrates that the technology works. The audit function identified the discrepancy, but also that a motivated individual can exploit the access window between withdrawal and return if the physical security of vials is not independently verified. Healthcare policy discussions following this case and similar cases have focused on several intervention points. earlier identification of nurses displaying signs of substance use disorder, improved reporting and response to positive drug tests in healthcare employment, cross-institutional information sharing through state licensing boards, and the design of dispensing systems that further reduce the opportunity for tamper and return conduct. The permanent license surrender is the most consequential long-term outcome of McNeely's case. From a public safety standpoint, she cannot be licensed as a nurse in Texas going forward. The criminal sentence, jail time and probation, addressed the criminal conduct. The licensing action addressed the professional status. Case 8. Clifford Russell Harris. Surveillance cameras recorded him picking the lock. The pain management clinic at Healthcare Express in Texarkana, Texas was closed. The clinic was dark. There were no patients, no witnesses, and no staff. But the cameras were running, and they captured Clifford Russell Harris, a registered nurse with authorized daytime access to that facility, breaking into the medication storage area after hours. What the cameras documented next was the evidence that would drive a federal prosecution for tampering with pharmaceutical products that were still in the clinic's supply chain, available to be administered to patients at the next day's appointments. Case 8 is Clifford Russell Harris. Clifford Russell Harris was a registered nurse who also held a licensed vocational nurse credential, both issued by the Texas Board of Nursing. He was employed at Healthcare Express in Texarkana, Texas, a pain management and urgent care clinic that maintained a controlled substance inventory for patient treatment. Pain management clinics operate under specific federal and state regulations regarding controlled substance storage, documentation, and administration, given the high-value nature of opioid medications and the regulatory scrutiny applied to pain treatment facilities. The period of Harris's conduct ran through the middle of 2018. During that time, he removed approximately 600 vials of controlled substances from the clinic's inventory. The medications he accessed included morphine and meperidine, marketed under the brand name Demerol, opioid analgesics used in pain management and acute care settings. The scale of the theft, 600 vials, was substantial enough that its absence from inventory would eventually have been identified through any serious audit process. But the tampering element of the case made it a federal matter, not just a theft. On December 29, 2018, surveillance cameras at the clinic recorded Harris picking the lock of the pain management clinic after hours and gaining unauthorized access to the medication storage area. Inside, he accessed vials of fentanyl, a Schedule II synthetic opioid significantly more potent than morphine. He emptied those vials of their fentanyl content and refilled them with another liquid. Those tampered vials were then returned to the clinic's pharmaceutical supply. The return of those tampered vials to the supply meant that patients scheduled for appointments at Healthcare Express could have received injections from those vials, believing they contained fentanyl. Instead, the vials contained whatever substitute liquid Harris had used. Depending on the patient's condition and the intended therapeutic purpose of the medication, the administration of an ineffective substitute rather than the prescribed controlled substance carries clinical risk. In a pain management setting, a patient whose pain control fails during a procedure or in the post-procedure period because the medication in the syringe was not what it was labeled to be, faces a direct consequence of that substitution. Harris was arrested on January 4, 2019, following the identification of the tampered vials and the review of the surveillance footage. The Texarkana Police Department's Special Investigations Unit conducted the initial investigation in coordination with the Drug Enforcement Administration. The Texas Board of Nursing initiated its own proceedings. On November 12, 2019, the board entered a default order revoking both Harris's registered nurse license and his licensed vocational nurse license. The board's order cited the surveillance footage documentation and described him as having been observed on video surveillance picking the lock while the pain management clinic was closed, followed by the discovery of the tampered vials. Both licenses were permanently revoked. On the federal criminal side, Harris entered a plea of guilty on June 16, 2020, to the charge of tampering with a consumer product, a federal offense under the product tampering statute. State charges that had been filed in Bowie County were dismissed in favor of the federal prosecution, reflecting a joint decision by state and federal prosecutors about the appropriate forum for the case. Harris admitted in his guilty plea that he had acted with reckless disregard and extreme indifference to the risk his conduct posed to the patients who might receive the tampered medications. That admission was incorporated into the plea record and was before the court at sentencing. On October 22, 2020, United States District Judge Robert W. Schroeder III sentenced Harris to 24 months in federal prison, to be followed by 3 years of supervised release. The case was prosecuted by Assistant U.S. Attorney Jonathan R. Hornock under the supervision of U.S. Attorney Stephen J. Cox for the Eastern District of Texas. Harris was represented by defense attorney Michael Friedman. The Clifford Harris case illustrates the federal product tampering statute as a prosecution vehicle for healthcare workers who tamper with medications and return them to the supply chain. The statute, typically associated with consumer product safety incidents in retail settings, applies in the medical context when a professional, with access to medication supplies, adulterates those products in ways that endanger the people who will receive them. The federal framework allowed prosecutors to address not only the theft of the controlled substances, but the separate and more serious conduct of returning compromised products for patient use. The combination of surveillance footage evidence, physical evidence from the tampered vials, and the Board of Nursing licensing records made this a well-documented case for both the federal prosecution and the professional licensing proceedings. The simultaneous resolution of the criminal case and the licensing revocation represents the standard two-track accountability process, criminal justice and professional licensing, that applies when a licensed healthcare worker commits crimes in connection with their professional access. Case 9. Lisa Jo Cooper and Kesia Danielle Johnson. The family had installed a Ring camera in the room, not because they had specific concerns about any individual staff member, but because they wanted to monitor their loved one's care and well-being in the nursing home where he had been placed. The camera recorded an incident on October 2, 2022. What it captured would lead to criminal charges, a grand jury indictment, and a case in the Galveston County District Court that became a documented example of why patient monitoring technology matters in long-term care settings. Case 9 is Lisa Jo Cooper and Kesia Danielle Johnson. Lisa Jo Cooper and Kesia Danielle Johnson were employed as caregivers at Solidago Health and Rehabilitation, a nursing home and rehabilitation facility in Texas City, Galveston County, Texas. Texas City is a coastal industrial community south of Houston, and Galveston County is part of the greater Houston metropolitan area. Solidago Health and Rehabilitation served a resident population that included elderly individuals and those requiring rehabilitation services following medical events or surgical procedures. The resident at the center of this case was an 87-year-old man, an amputee with arthritis, who had been placed at the facility for care. His family, as is the right of nursing home residents and their families under federal nursing home regulations, had installed a camera in his room. Room cameras in nursing homes are permitted under Texas law with appropriate disclosure, and their use has increased significantly as families have sought additional means of monitoring the quality of care provided to vulnerable relatives who may not be able to fully advocate for themselves. On October 2, 2022, the camera recorded an incident involving Cooper and Johnson. The footage documented conduct toward the resident that his family immediately identified as requiring law enforcement review. The family contacted Texas City Police and filed a formal complaint. At the time the complaint was filed, the facility had attributed injuries the resident had sustained to a fall, a common and sometimes legitimate explanation for injuries in elderly nursing home patients, who are at elevated statistical risk for falls due to mobility limitations, medication effects, and age-related balance factors. The camera footage provided an independent account that contradicted that explanation and documented the source of the resident's injuries. Both Cooper and Johnson turned themselves into law enforcement between October 6 and 7, 2022. The facility conducted an internal investigation and terminated both employees following that review. The case was presented to a Galveston County grand jury. On February 7, 2023, the grand jury returned an indictment on charges of injury to an elderly or disabled person with intent to cause serious bodily injury, a second-degree felony under Texas Penal Code Section 22.04. The indictment was filed in the 122nd District Court and subsequently assigned to the 405th District Court before Judge Jared Robinson. The resident's grandson, Lisandro Solis, spoke publicly following the charges and encouraged other families of nursing home residents to install monitoring cameras in their loved ones' rooms. His statement reflected a broader public discussion about the role of personal monitoring technology in detecting and documenting care quality concerns in institutional settings. This case is documented through the indictment stage. The arrest and February 2023 indictment are confirmed by court records and multiple news sources. The final disposition of the case, the outcome of the proceedings in the 405th District Court, including whether the defendants were convicted, entered pleas, or had the charges resolved in any other manner, requires verification through the Galveston County District Clerk's Office. Any documentary presentation of this case should confirm the final outcome before stating a verdict or sentence. The Cooper and Johnson case reflects a pattern of elder abuse documentation that has been significantly affected by the spread of personal monitoring technology. Prior to cameras, many nursing home abuse incidents were difficult to prove because they occurred in private spaces without independent witnesses. The residents' injuries in this case had an alternative institutional explanation, the fall narrative, that might have been accepted had the camera footage not existed to provide a documented account of the actual events. Texas law regarding nursing home resident rights includes specific provisions about the right to have monitoring devices in resident rooms, the obligation of facilities to respond to complaints, and the reporting requirements for injuries sustained in care. The Solidago case and similar cases have contributed to ongoing policy discussions about camera access in long-term care settings, the accountability of frontline care staff, and the standards applied to injury documentation in nursing homes. The broader context of elder abuse in institutional settings is documented in national statistics from the Department of Health and Human Services and state-level data from the Texas Long-Term Care Ombudsman Program. Nursing home staff with direct care responsibilities for elderly residents occupy positions of significant trust and physical authority, and the criminal and regulatory systems must work together to respond effectively when that trust is violated. Case 10. The Novus Nursing Assistant Financial Exploitation Cases. 2 Texas facilities. 2 healthcare workers. 2 elderly patients whose financial accounts were accessed without authorization. The crimes in these cases did not involve medication, clinical procedure, or physical contact. They involved the exploitation of the financial vulnerability that often accompanies cognitive impairment and institutional placement. Both cases moved through the Texas criminal justice system as documented examples of a category of patient harm that receives less public attention than clinical crimes, but that affects a substantial number of nursing home and assisted living residents across the state every year. Case 10 involves 2 documented Texas nursing facility financial exploitation cases. The first involves Robin Nicole Calica, the former business office manager at the Heights on Huebner, a nursing facility in San Antonio, Texas, in Bexar County. Calica held an administrative position, business office manager, rather than a direct clinical nursing credential. Her role gave her authorized access to the financial systems of the nursing facility, including the resident trust accounts that nursing homes are required by federal law to maintain on behalf of residents who cannot independently manage their own finances. Resident trust accounts are a regulated financial structure. Federal nursing home regulations require that facilities maintain these accounts separately from the facility's own funds, provide residents with written statements of their account activity, and not misappropriate resident funds under any circumstances. The Office of Inspector General of the Department of Health and Human Services and state Medicaid fraud control units routinely audit nursing facilities' management of these accounts. In Calica's case, investigators from the Texas Attorney General's Medicaid Fraud Control Unit identified a systematic misappropriation of funds from the resident trust account and from the personal financial accounts of Medicaid recipients living at the facility. The total amount identified as misappropriated was $309,044, a sum accumulated over a period of unauthorized access. The investigation was conducted by Lieutenant Jeff Winnie and Captain Raul Gonzalez of the Texas Attorney General's Medicaid Fraud Control Unit. The unit operates under the Texas Attorney General's Office and has a specific statutory mandate to investigate and prosecute fraud involving Medicaid funds and the exploitation of Medicaid recipients in healthcare settings. The financial forensic analysis required to document the full scope of the misappropriation involved detailed review of account records, transaction histories, and the paper and electronic trails associated with the resident trust accounts. Calica pleaded guilty to second-degree felony theft. The case was resolved with a sentence of 10 years in prison. The sentencing was announced on March 20, 2023. Restitution was ordered as part of the sentence. Attorney General Ken Paxton issued a public statement following the sentencing that addressed the vulnerability of nursing home residents and the obligation of the state to protect individuals who have been entrusted to institutional care. The second case involves Destiny Lashell Houston, a certified nursing assistant employed at the Forum at Lincoln Heights, a nursing care facility in San Antonio, Texas. A certified nursing assistant is a licensed healthcare worker. The CNA credential is issued by the Texas Department of Health and Human Services following completion of a state-approved training program and a competency exam. CNAs provide direct care to residents, including assistance with daily activities and basic health monitoring. The case against Houston centers on allegations that she used the debit card of a 79-year-old resident at the facility, a resident with Alzheimer's disease, for unauthorized transactions. Alzheimer's disease causes progressive cognitive impairment, and residents in advanced stages of the condition are typically unable to monitor their own financial accounts, recognize unauthorized use of their financial instruments, or report that exploitation to authorities. That cognitive vulnerability makes Alzheimer's patients at particular risk for financial exploitation by individuals who have access to their personal belongings and accounts. Houston was charged in 2026 with 3 counts of third-degree felony, the specific Texas charge applicable to the exploitation of an elderly or disabled individual. The charges were filed by the San Antonio Police Department's investigators following a complaint. As of the documentary research date, this case was at the charging stage only, with no conviction, plea, or sentencing on record. Any presentation of this case must accurately reflect that it involves pending charges, not adjudicated outcomes. These 2 San Antonio cases together illustrate the financial exploitation dimension of patient harm in healthcare settings, a category of crime that operates entirely outside the clinical environment and targets a different kind of vulnerability than the pharmaceutical or physical crimes documented in the preceding cases. Both elderly patients and patients with cognitive impairment are at elevated risk for financial exploitation precisely because their institutional placement creates situations where other individuals have authorized or unauthorized access to their financial resources, while their own ability to monitor and protect those resources is diminished. The Texas Attorney General's Medicaid Fraud Control Unit, which led the Calica investigation, represents a dedicated state-level law enforcement resource for exactly these cases. The unit's mandate covers both the fraud against the Medicaid program itself and the exploitation of Medicaid recipients, a dual focus that reflects the recognition that financial crimes against vulnerable healthcare populations damage both the individuals directly harmed and the public programs that fund their care. The broader statistical picture in Texas: the Texas Long-Term Care Ombudsman Program receives thousands of complaints annually related to nursing home and assisted living facility conditions. Financial exploitation represents a documented and growing category within those complaints. The state's Adult Protective Services Division also investigates exploitation reports for individuals who are vulnerable due to age or disability. The policy response to financial exploitation in nursing home settings includes mandatory reporting requirements, resident rights education, facility auditing of trust accounts, and criminal prosecution of individuals who exploit their access to resident funds. The Calica conviction demonstrates that the Texas criminal justice system treats this category of crime seriously. A 10-year sentence for theft from nursing home residents reflects the aggravating weight that courts apply when the victims are vulnerable individuals placed in institutional care.